Welcome everybody to our Building Safety Law SB 4D webinar today. I am joined by my partner, Steve Mezer from Tampa and Rob Caves from our Fort Myers office. And we are going to be walking and talking through this law. It's an 88-page law. I'm going to say at the outset, this is a very complicated law. It's bringing sweeping changes. It was designed to address the physical condition of multifamily buildings and the fiscal preparation needed to address those physical conditions. I'm going to use the typical lawyer disclaimer. We are not dispensing legal advice for your association. We are going to encourage you after this conversation to reach out to your association counsel and discuss what you've heard here today. And as Laura said, this is being taped. Becker does have a web page set up. It is www.flbuildingsafety.com. And this webinar will be placed on that web page. And in addition, we're going to be updating that web page regularly as things come out. You know, we're 2.5 years out from many of the deadlines contained in this bill. So there's going to be information that comes out throughout the course of those 2.5 years. We've got 2 more legislative sessions before many of these deadlines. So we're anticipating a lot of information that we will need to be discussing on an ongoing basis. So with that being said, I will say lastly that we may run over an hour. So we're going to stay as long as we've got questions and we can get to them. So we may be running over about 15 to 20 minutes. Guys, are you okay with that?
Sure.
You don't have a choice, right?
It was up.
So Steve, let me start by asking you, because we've got people here, to whom does this new law apply?
Hey, Donna. Condominiums, obviously, first, if you are subject to 718, cooperatives subject to 719, and you are 3 stories or higher, and there are a couple provisions that do address managers as well. So if you're a CAM, there are a couple provisions of interest to you, but I also think that we have to be mindful of who it does not apply to. For example, if you are a Chapter 720 homeowners association, single family homes, 2-family and 3-family dwellings with 3 or fewer habitable stories above ground. And I'm reading that right from the bill, the statute, because I think it's slightly in conflict. You know, the 3 stories or above, but that is an exact quote out. Again, HOAs, homeowner associations, single family homes, 2-family and 3-family dwellings with 3 or fewer habitable stories above ground. They're exempt from this, but if you're a condo or a co-op 3 stories or higher, you are well within the statute.
Steve, can we say from the outset that we are going to encounter some inartful language throughout this bill that's going to be subject to interpretation? And I can imagine many associations are going to want to get legal opinions.
Yeah, absolutely. You know, and it can get right down to a single word, whether it's single or plural, or the word choice itself. It's a fascinating study of legislation. Obviously, there are going to be diverse opinions on it. My mailbox has been full of people opining as to all kinds of things in this bill, but I think it's important for us to look at the bill as it reads today. This is Florida law today, and so we as community association practitioners, boards, managers have to follow this law and not try to speculate or guess as to what the legislature might do with a particular provision or word. Yeah, there's a lot of people advocating, perhaps with self-interest, perhaps because of practical issues. That may or may not come to pass. We have to deal with the law as it reads today.
Really, really good point. Also, Steve, we're talking today, this webinar is talking today about a state law. Now, there are other ordinances that are being passed, that have been passed or are likely to be passed. So I think associations need to be mindful. You just ran through to whom this law applies, but there may very well be local ordinances that also impact some of the associations that have joined in today.
Yeah, absolutely. Back in the 70s, Miami-Dade started theirs with a 40-year certification. About 2006, Broward started it, and then Palm Beach County, City of Boca Raton, and even Hillsborough County are all trying to get something similar to this, but there's no way that they're all going to align with it. So if your property is located in any of those jurisdictions, be mindful of your local requirements as well. This does not supersede those or exempt you from compliance with the local requirements.
So Rob, most of the people that have joined are going to want to know two things right off the bat. Steve just covered the first, which is, does this apply to me? The second big question is, what are the deadlines? Because, we're going to be talking throughout this webinar about the penalties, but first of all, what are the deadlines across the board that this new law institutes?
Sure. So there's a couple of, deadlines that associations need to be aware of. The first is that by January 1st, 2023, every condominium association has to report to the division information regarding their buildings, how many buildings they have that are over 3 stories in height, how many units, their address, county they're located in, etc. The statute contemplates the division creating a form that associations have to fill out and turn in, essentially. I checked right before, the division's website does not appear to yet have a form. So we have, 6 months and counting, or less than 6 months almost, to respond to that. So that's really the first deadline, is a reporting deadline that every association is going to have to report to the division.
And before you get off that, I'm going to reiterate that when we get that form, we will put that on that landing page I mentioned at the outset, the floridabuildingsafety.com. Do we know, though, I looked at that language, Rob, do we know what the division plans to do with that information?
Well, it says they're going to then publish that information, I believe, on their website. So you'll be able to essentially search for condominiums that have buildings of 3 stories or greater. And they have to provide the number of such buildings, the address, the county it's located in. So it's going to be published in some type of report by the division, presumably, on their website, searchable by individuals who want that information. So, and then there's also language in the bill talking about reporting that the building officials is a different issue, that they have to report to the legislature regarding, the milestone inspection information. So I guess with the idea the legislature may, refine that. The other deadlines are dealing with the 2 reports that are, I think, the meat of this new law, which is the milestone inspection report and the structural integrity reserve study. With respect to the milestone inspection, if you're a condominium association who has a CO date of July 1st, 1992 or earlier, you have to complete your milestone inspection no later than December 31st, 2024. So that clock is running. The other deadlines for condominium associations or cooperative or condominiums that are required to do a milestone inspection, if you're newer than July 1st, 1992, your deadline is either 25 years from CO if you're within 3 miles of a coastline, or 30 years from CO if you're more than 3 miles from a coastline. And the statute includes a technical definition of coastline as it's defined in the statute. So if you have a question as to whether you're a 25-year clock or a 30-year clock, you need to, review that with counsel, because it is a technical definition. One of the
questions we've gotten is, what if we have a large community and only a portion of the community is it within 3 miles? What if it's just like 1/2 of one building hanging out there and the rest isn't?
Yeah, I think that's an open question. Can you just do the 25-year report on one building and the 30-year report on every other building? I don't think we know the answer to that under the law. It seems to talk about in terms of buildings, because we have clients that are, I have clients that are condominium associations, and they have buildings that are 3 stories and buildings that are less than 3 stories in the same, association. So that raises, similar questions. That's a question I would tell an association to review with counsel. You need to determine, what your obligations are, what risks you may be entertaining if you're aggressive versus, is it, better to be conservative, particularly in that situation where you're talking about a 5-year difference on when you're going to have to do the report anyway. Once you've done a milestone inspection, your next deadline is 10 years. This has to be done every 10 years, regardless of when your initial triggering date is, whether it's 2024, 25 years, 30 years, thereafter, you're on a 10-year recurrent clock. The other deadline has to do with the structural integrity reserve study. If you're a building of 3 stories or more, you now have to have a specific type of reserve study done for certain components. We'll talk about that in detail in a little bit, but there the deadline is again, December 31st, 2024. You have to have that study completed by then, so that your budget for 2025 reflects the reserves required by that specific reserve study. So there's a number of deadlines. All of them are relatively on a short horizon. Some of them this December, some of them, 2 years plus from now.
So we hope everybody has a good planner, calendar planner. So Steve, the law creates a new subsection to chapter 553 of the Florida statutes. And Rob just talked about the deadline for milestone inspections. I want to start out talking about these milestone inspections. There's 2 phases to those inspections. Can you walk us through them?
Sure. The milestone inspection is a structural inspection of the building. So you're looking at load-bearing walls, primary structural members, primary structural systems. Those are words of art. It's really interesting because those terms came from a statute at 627.706 for those who want to look at it. The terms are defined in a statute dealing with sinkhole insurance. But that's where they're going with this. It has nothing to do with sinkholes, but those terms, the load-bearing walls, primary structural members, primary structural systems, they're defined in that statute and they're incorporated by reference. The inspection part has to do with the visual inspection by a licensed architect or engineer licensed to practice in this state. Okay, so it was interesting, Donna. I yesterday got a nice solicitation. It was in a box that came by FedEx. So I know it was important, from an out-of-state engineering company wanting to do all kinds of structural things here for my clients. And I'm wondering if they're trying to pick up the slack from these reports going, well, while the Florida engineers and architects are going to be busily doing these inspections, we, the out-of-staters, will come in and help your clients. I thought it was so kind of them to offer that.
We knew that was going to happen. We see it every hurricane season too. So
yeah, absolutely. So the first phase is going to be that structural inspection by the architect or engineer. If they find that there's a problem, then it's going to go into the phase 2, and I think that's going to go to Rob, who's going to talk a little bit about that, because there's some interesting words in the phase 2 description that are really what you were talking about earlier, Donna, about words appearing in legislation that may have questionable meaning.
But just before we go to Rob, visual inspection does not mean your engineer drives up in the car and peeks his head or her head out of the window and looks at the building.
Absolutely not. And I don't think any of them are going to do that. Given the issue here of life safety, or at least structural integrity, it's really not life safety. I want to go back on that. It's not a life safety inspection as much as the structural part. Now, yes, they are going to address life safety components, but it's not the same. One of the things that we may get to later is that the fire marshals are looking separately at the life safety issues, but their report's not due until, I believe it's 23 or 24, it's out there, as opposed to the structural part, which is under the engineers and architects part. But if the phase 1 shows substantial structural deterioration, any kind of distress, looking at imperfections such as cracks, sagging, deflections, misalignment, signs of leakage, peeling of finishes, then the licensed engineer or architect performing that phase one needs to report that and go to the phase two.
So Rob, you get the fun job of telling us what substantial deterioration consists of, because that seems to be the triggering event for an engineer or architect to say, okay, now you need to do a phase two, which could involve or may involve destructive testing, correct?
Yeah, right. So the statute defines substantial structural deterioration. I mean, that's a defined term in 553 now, and the legislature defined it as substantial structural distress that negatively affects a building's general structural condition and integrity, but does not include, as Steve said, surface imperfections, cracks, peeling paint, misalignment, unless the engineer performing the inspection determines that such imperfections are a sign of substantial structural deterioration. So, it really is, while it's defined in the statute, I think it really boils down to the person, whether it's an architect or an engineer doing the phase one inspection, what their opinion is as to the condition they're observing. If in their opinion, is that crack superficial, or is that crack representing substantial structural deterioration? And I think it's beyond, our area of expertise, or probably most people on this webinar, on what that ultimately will mean. I mean, that's something the engineer in their report is going to have to describe.
Now, I recently had a conversation with an engineering company that does business throughout Florida, and their position was that only a special inspector could perform a phase two of the milestone based on the other language in chapter 553. And I'm not asking for an answer on this because I know there isn't one right now, but this is just one of those areas where as we dig into this new law, more and more questions are cropping up.
Absolutely. I think that's, an area where, to take Steve's admonition earlier, don't count on the legislature giving us any help in the future on clarifying this, but that's certainly something with respect to who and how that phase two report is done, clarification would be helpful. But I would say, notwithstanding that open question as to whether a special inspector has to do a phase two inspection, when an association is interviewing and contracting with the architect or engineer to do the milestone inspection, it should be discussed at the outset, who and how will a phase two inspection be done if it has to be done. Now, they may not be able to answer on how much destructive testing is required until you do the phase one study, but understanding that the engineering firm you're contracting with has the capabilities of doing structural phase two inspections is important, whether it's a special inspector or not.
Right. It's a really, really important point, because we don't know whether or not engineering firms have updated their proposals. This bill just became law a few weeks ago, so they may still be relying upon and presenting the proposals they've used for years. And the point we're trying to make here is those proposals may not be sufficient to address these new statutory requirements.
Absolutely. I think that it's fair to say they're not going to be sufficient, only, if only because the statute has specific requirements for the report. A phase one report, even if that's all that has to be provided, the person, whether it's an architect or an engineer that's doing the phase one report, has to prepare a specific summary. In addition to the report and the summary has to be delivered in a particular manner to the building official and to the association, and then the association has obligations. So, even if they have current agreements, they're not going to contemplate these new reporting requirements that need to be specifically outlined in the agreement with the architect or engineering firm to make it clear that what they provide at the end of the day is going to be sufficient to satisfy the new requirements of the statute.
Well, I think you kind of let Steve off the hook, because my next question is, we're already, at Becker, our phones have been ringing off the hook. Our inboxes are flooded. And one of the questions we're seeing with some regularity is,
Yes.
hey, we just did an engineering report a few months ago, okay? Will that qualify for this milestone inspection, or do we have to pay to get a new report? Stephen?
Yeah, well, if that's a question to me, the answer to that probably is going to be no. As Rob was indicating, it will not meet the parameters of the statute. In real life, sure, you'll probably talk to that same engineer and try to work out a discount or some arrangement, but he or she is not likely to just sign off and go, well, they did that 6 months ago, so now you are timely and fully compliant with the statute. I don't think that is going to happen anywhere. So yeah, you can try that, you can think it, but no, I don't think that's going to be your reality. You might get a slight break in the cost, but the bottom line is no, you're not going to be in compliance with the statute unless that engineer is willing to sign off on it, do the summary that Rob talked about, do the report that Rob talked about, get it to the building official, and not charge you a whole lot of money. So don't plan on that.
Okay, I knew you were going to say that. Rob, the architect or engineer has completed phase 1 of the milestone inspection. He or she has not really found anything that would require the next step, which is the phase 2, more invasive testing. Now, what are the reporting requirements? To whom must that architect or engineer send that report?
Right. So to back up one thing, because I think we did gloss over one point, and that is, while we talked about the deadlines for these reports, the statute contemplates that the local building official is going to determine who has to do the milestone inspection report and will send a notice to the association that is obligated to do a milestone inspection, and the association must complete phase 1 of the milestone inspection within 180 days of receiving that notice. So I don't think that is the trigger for having to do a milestone inspection. If you're obligated to do one, you're obligated to do one. But the statute is contemplating that the building official sends a notice advising the association that one has to be done and you have to do it within 180 days. And that's important because that ties into the reporting. The engineer or architect who does a phase 1 study has to issue that study or that report to the building official. The summary and the report is issued to the building official directly by the architect or engineer doing the
And let me stop
inspection.
you here, because that is a significant difference from the 40-year certification, where the engineer would deliver that report first to the association directly.
Right.
And then it was up to the association to deliver that report to the local authority having jurisdiction. What you've just said is incredibly important. People need to hear that, because it is going directly from that architect or engineer to the local authority. The association is no longer the intermediary on that.
Correct. So, the building official is going to get the report and it's going to say what it says. Now, in addition to that, the architect or engineer provides that summary and report to the association, and then the association has specific obligations. The association has to mail and email to those owners who have consented in writing to receive official notice by email, or hand deliver or otherwise deliver to all of its unit owners a copy of the summary, and state that make sure I get this right. They provide the summary and state that the report's available. And you also have to post those documents on your website if you're obligated to have a website. And then those reports become official records of the association. We'll touch on that later. So the association has to provide. I'm sorry?
Rob, do they have to post it on the property?
Oh, and they have to post a summary on the property.
Summary.
Yeah. The summary.
Conspicuously.
Yeah.
So everybody coming, I found it interesting that it said, regardless of the report's findings. I think that was a little glimpse into the mindset of at least the drafters, perhaps even the bill sponsor, that in the past, if a board didn't like the findings, that they, didn't talk about it. I mean, Steve, to that point, if you know, the association gets this report and they don't agree with it, and sometimes that's driven by unit owners who say, we don't, you know, we wouldn't have chosen that engineer or that architect. We disagree. Everybody knows somebody who's a better professional advisor that the board should have chosen, right?
Right.
Can the board seek a peer review or second opinion on the milestone inspection?
Well, as to the peer review, I don't think that's going to be real helpful because the building official already has the original. If you're looking at maybe the cost, we can go down that path a little bit. That's probably not part of the peer review. Second opinion might be an interesting way of going if the second engineer is actually going to disagree with the first one. I don't know how likely that one is either, and whether you have the money to spend on that gamble or risk. But there's nothing here that prohibits you from doing that. But the building official already has the statutory one, so I'm not sure whether the building official is going to put any value in it. And so you're already going down that path. So I think, Donna, the message here is pick your engineer, your inspection firm carefully. I think pretty soon, very well into, say, the next year, we're going to see those who are most competent and those who can be trusted by various condominium associations, and those that it may be perhaps too conservative or too aggressive, depending on how you're looking at it, in their reports. And so I think this is where getting references and doing your investigation before they do the report is going to be really important. And getting with your attorney to make sure that the contract engaging that professional is appropriate for your scenario.
Yeah, I agree. So let's talk about, listen, the stated goal for this legislation was transparency, right?
Very much.
So who's entitled to see this, Rob? I mean, potential purchasers, potential tenants. When I asked before about the reporting requirement to the division, I'm wondering who's looking that up. I mean, is that designed for potential purchasers and tenants? I don't know, but it seems like they're gathering the information for a purpose. And I know, we all know that the stated intention for this legislation was transparency. So can you talk a little bit about who's entitled to see the milestone inspection? Who's not, we already know owners are.
Right. So existing current tenants, you know, not prospective tenants, but tenants are entitled to inspect limited documents, the declaration, the rules and regulation, and now the milestone inspection and the reserve, the structural integrity reserve study have been added to that list. So tenants are entitled to inspect and get copies of those documents.
Rob, could I jump in for a second? Does that mean tenants or renters?
Well, the statute says renters. So I guess it doesn't say occupants. The term in 718.111.12 is renters. So I think that is a person occupying a unit in exchange for consideration.
Thank you.
You know, a non-unit owner occupant who is not designated the personal representative for the purpose of inspection by the owner, you know, is a stranger to the association and not going to have statutorily protected rights for that information. So they would have to get it through their owner. It's a good point. With respect to prospective purchasers, from the association's perspective, the statute has not been amended to state that the association must provide the milestone inspection to prospective purchasers. However, the non-developer unit owner disclosures in 718 and 719 have been revised to state that unit owners who are selling their units have to provide a number of documents, including the milestone inspection and the structural integrity reserve study, or a statement that they have not been performed. So those have to be provided to prospective purchasers by the selling unit owner to prospective purchaser.
And that's good to know. And I imagine the Flawbar contract is the condominium writer is going to be updated to address.
Right, so that'll have to be updated to include that in the list of disclosure items, which include, the declaration, financial reports, et cetera.
And it's no surprise that this legislation brings some significant cost increases, in terms of reserve. And we're going to get into reserves. We're almost at the halfway mark here. We're going to get into the new structural integrity reserve. So we know with regard to reserve funding, there's going to be increased costs. These inspections are going to cost money, and certainly the repairs that the inspections highlight are going to cost money. So Steve, we know what happens is, and this is not a surprise, that people think maybe we can do some volunteerism here and save some money, right? Because this is going to cost a lot. So what would you say to a board member? And I've already had this question, okay? This is not just pure speculation that the community has a licensed, Florida licensed engineer on the board. And, heck, maybe Joe can perform the milestone inspection.
No, thank you. Yeah, and it's the same way, regardless of what that profession is for a board member or even a resident in the condominium or co-op. We do want the independence of an architect or engineer, particularly when we're dealing with structural issues, life safety issues. So I'm not even sure if I was a prudent architect or engineer that I would want to be volunteering because of the potential liability. But please, boards, turn down the idea of volunteerism when you're dealing with this kind of a study.
I would strongly agree with you, Steve. And before we move into the reserve study, I guess I'd ask you both, what are you telling your clients right now? We know that there's thousands of associations that are going to need to undertake these milestone inspections. And look, there is a limited number of professional engineers and architects in Florida. We know you've said that it needs to be Florida, somebody who's licensed to do business in Florida to perform these services in Florida. And there is the open question as to whether or not the phase 2 of the milestone inspection requires the services of a special inspector, which has even a greater limitation on the number of engineers in Florida who have that accreditation. So what are you telling clients now? I mean, we're 2.5 years out from deadlines. What are you telling them?
I'm telling them to be aggressive about it and to plan ahead. Make arrangements now with your friendly engineer or architect. Donna, by the way, as of February 8th of this year, there were 40,789 licensed engineers in Florida and 11,308 licensed architects. When you think about it, that is not enough to go around no matter how we do this. So planning ahead is going to be required. And, we've touched on this a little bit, Donna, about the liability of the association for not complying. I think if you have tried to comply, you've contacted architects and engineers, companies to do the inspections, and you've been unsuccessful, and you were trying well in advance, that's far better than waiting till it was due and finding that, nope, they can't get to you this year or next. So plan ahead.
Rob?
I agree. I mean, I think if you are a condominium or cooperative association that's pre-1992 and you know that your deadline is December 31st, 2024, you need to be starting now, getting a contract or an agreement or interviewing engineers or architects, to get that ball rolling. It's not going to get better the longer you wait. And, waiting and crossing your fingers, hoping that you're going to get the can kicked down the road by the legislature is a bad decision because
Right.
I don't think there's the appetite for that.
Assuming an impossibility of performance argument is going to be accepted by your local authority is a big assumption.
Well, and also, you have a duty to your owners, and even, you could be sued by your owners for failing to get a building. What is it going to do to your ability to sell units in a condominium building that is overdue on a milestone inspection? I'm not giving this as an opinion, but I can't imagine you could get a mortgage.
Or insurance.
Or insurance. I mean, I think calamity is probably the word I would use if you blow these deadlines. Everything's
I
bad.
don't want to add to the misery, but I'm gonna announce one more deadline here. The engineered life safety system, January 1, 2024. Pre-92 buildings. Even if you've opted out of full sprinklers, you still have a pending
Yeah.
deadline of January 1, 2024 for that engineered life safety system. And that was going to be an issue even before we've had this new mad rush to get engineers and contractors to perform work.
Yeah.
So that's even a closer deadline.
Yeah. So you need to be doing it now. I mean, that's something I would tell and am telling associations. We have to be having these conversations, reaching out to appropriate professionals now, because it's only going to get harder and more expensive and more problematic as we get closer to the deadlines.
So let's move into the next stage of this new legislation, which is the requirement for a structural integrity reserve. We know that the new law requires this structural integrity reserve to be maintained as part of the official records for 15 years. I think that alone underscores how serious the legislature is taking this particular reserve study. So Steve, if you can kick us off, what constitutes a structural integrity reserve study and who can perform it?
Okay, there's actually now a new definition. It's in 718-103. It's now sub 25 as far as what that study is. And then you get into the 718-112 section. It says an association must have a structural integrity reserve study. And if I see all my emails coming through, they just abbreviated SIRS. So if you see that, that's what it's referring to. Completed every 10 years after the condominium's creation, which is kind of an interesting phrase because it's not the certificate of occupancy necessarily. It says condominium's creation for each building on the condominium property, interesting term, that is 3 stories or higher in height, which includes at a minimum, and then it gives you a list of items, and it's worth going through for a moment. The roof, load-bearing walls or other primary structural members, floor, foundation, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows, and then the last section, any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000, and the failure to replace or maintain such item negatively affects the items listed in A through I. And it says, as determined by the licensed engineer or architect performing the visual inspection portion of the structural integrity reserve study. So that's what it is.
So you've got a reserve specialist who can do part of this reserve study, but you're going to need a licensed architect or engineer to do the other portion. Can you explain the difference between?
Yep. The structural components that I just listed will be inspected by that architect or engineer. The cost factors can be done by what people fondly call, I guess, reserve specialists, people who are able to do costing. And candidly, I hope this isn't being recorded, I think those folks probably do a little better job with the cost factors. I know. They do a better job usually with the cost factors. And well, I have been practicing long enough to remember the good old days where you might call the person who does the roofing or plumbing or electric or waterproofing, whatever it is, and get them to give you a valid quote on it. These days, we have specialists who do all of those components and do a very good job at it for the most part.
I know reserve companies are very disappointed because a lot of them do not have licensed engineers, do not have reserve specialists who are licensed engineers or architects. So I guess they're in a position right now to again try to go back and revisit the law with our legislators, or perhaps acquire those people, acquire that accreditation.
Yeah, they're going to have to do something in order to qualify, because this is one of the places, and throughout the legislation, there are some inconsistencies. Sometimes it'll say Florida licensed engineer. In this section, it says licensed under 471, which is the Florida statute for engineers, or 481 for the architects for Florida. So it is specific to that for the structural integrity reserve study.
I do want to make it clear that for many of the people listening, and I'm sure we've got a lot of treasurers listening to this webinar, this means to our treasurers, you are not qualified to prepare the reserve schedule related to the structural integrity components. Correct, Steve?
That's correct. And in fairness, do not expect your CAM to do it. You know, and so many people will say, well, you know, he or she has been in the business for many years. They know how much it would be to do this project. Please don't expect them to do it because they shouldn't be doing it. And I know they won't do it because the law specifies licensed engineer, licensed architect.
So Rob, when I talk to most, oh, I'm sorry, Rob, you wanted to.
Well, you know, it's like, how do you visually inspect an electrical system or a plumbing system? Some of it, I don't understand practically how that's going to work, but that may not be either here nor there.
I guess if it's sparking, Rob.
I guess. I guess. I mean, I just don't know.
It's a fair point. And then again, it only underscores how new this law is, how untested this law is, and frankly, probably how in need of a glitch bill will be next session. But Rob, as long as you propped up, you know, one of the big issues when I talk to my clients recently, I can't remember the last time I asked a client how they maintained their reserves and gotten the answer straight line. It's always cash flow, the pooled methodology. With this new structural integrity reserve, I know there's an impact on that, that they probably cannot be put into a pooled reserve, certainly not with the other reserves, the other statutory reserves.
Right. So I think there's two issues there. One, just what you said. At a minimum, if pooled reserves are still permissible, you have to at least have two pools, a pool of the structural integrity reserve study items and a pool of the non-structural integrity reserve study items. You know, if you have a paved parking lot that's not structural, it's just, you know, asphalt on dirt next to the building that doesn't therefore impact the structure of the building as provided in the statute. I mean, that could, you know, be a non-structural integrity reserve study item. If you have a swimming pool that's not on like an amenities deck or anything, it's just out, you know, separate from the building, that could be a separate item that's not structural. But if you have pooled reserves, I think they have to be separated now between the items in the structural integrity reserve study and the items that are not. But even then, I mean, I think it's an open question. The statute now prohibits an association from waiving or reducing or using for a different purpose the items listed in new paragraph G, 718.112 2G. You can't waive, reduce, or use for a different purpose effective December 31st, 2024. And the idea of a pool is you're using the money in that pool for a different purpose. Now, it has to be another item in the pool, but it's not the specific reserve purpose. So, you know, it's not clear in the statute. I think that some have indicated that they understood the intent of the legislature was to make it mandatory straight line. Now, it doesn't expressly say that.
Yeah.
And I think that, again, to your point about, I don't know if this is a glitch bill or just refinement, it should say specifically either A, you got to have straight line for these items, period, full stop, or B, if you have a pool, you can only have a pool with these items in the pool. I think the legislature should do one of the two. In the absence of that, you know, I think the conservative approach is not the answer clients want to hear, and that's put everything straight line. That's a structural integrity reserve item.
I mean, you can't go wrong with that.
You can't be wrong. You
Right.
cannot be wrong with it.
Absolutely.
I think it's defensible, arguably, to have a pool of just those items, but I think there's risk, and I don't know if the reward warrants the risk in doing that.
Who determines whether or not the other components impact the structural integrity reserve components? Is that a question for your engineer? Is that a question for your attorney? Is that a question for your accountant?
I know it's not a question for your attorney.
I'm so glad to hear that, Rob.
I guess, I mean, I think it has to be the engineer. They have to make that determination of what those items are.
Right, if there was a reserve for the seawall and if there's an impact to the seawall, I guess that could potentially impact the other structural integrity reserve components.
Yeah, I think it's going to be very fact specific. I mean, going like the swimming pools on an amenity deck that is integrated to the building, absolutely going to be part of that, right?
Right.
Swimming pools that are just, in the dirt next to the building, probably not. I mean, I think it's going to be a fact specific question. Paving on top of dirt next to the building, probably not. The pavers on
top of your parking structure.
Sure, right.
With the pool deck and plantings on it. I just talked about this in a recent podcast episode. Yeah, perhaps that does have an impact.
Right.
Okay.
And I have a ton of clients. This summer seems to be the amenity / parking deck restoration summer for my clients here on the West Coast. I have a ton of them that have those projects going on. So, that's going to be a question for the engineer.
I wonder if we're going to see developers changing some of their designs, although, given how much of a premium land is in Florida and elsewhere, again, everything's designed around density. How much can we pack into this vertical construction? Yeah. Interesting. So Steve, I'm going to give you a difficult question. One of the components in the new structural integrity reserve is for windows. But we know in many of our communities, the windows are maintained, repaired, and replaced by the owners as required by the governing document. So how do we reconcile the requirement that windows need to be part of this structural integrity reserve when the documents say something else?
Yeah, I think this is another good example, or bad example as the case may be, of the drafting issues here, that the persons passing this law didn't understand the facts that you just gave, Donna, that in many condominiums, there is a different allocation as to responsibility for maintenance, repair, or replacement of windows, sometimes wholly on the unit owner, sometimes partially. They pay for it, the association does it, or wholly with the association as a common element. And none of that is addressed here. So if we're making a list for possible things to address in a glitch bill, that might be on the list. It might not be. We don't know. So for the time being, get the report that shows exactly what the law requires, that the reserve study include windows. And then when the reserve analyst, as we call them, the person who's doing the costing, does that part of it, he or she can indicate this is not an association expense if that's what the documents provide, so that the numbers are there, our report is complete. But as far as funding the reserve, I don't want a condominium to fund a window reserve if it has nothing to do with the windows. Putting money there that we can't spend doesn't begin to make sense. So when we get the report, we want it to zero that number out.
I have a question there, Steve. Okay. It just came to mind. I mean, could this mean windows, other than unit windows, like the lobby windows and the windows in the gym? I mean, I guess that's one way to kind of parse that to make it make sense.
Maybe, Rob, and I'll go right back to your other example about the plumbing and the electricity. Is that just in the common elements?
We don't know. We know you have to put away the money. How you spend it, that's going to require a legal opinion.
Yeah,
it's going to, and it's again.
It seems that all of that in G1 should be clarified. If this is the intent of the legislature, that to the extent these are items that are the maintenance, repair, and replacement responsibility of the association as a common expense. Because plumbing and electrical is, a split issue. Some of it's inside the unit, some of it's the associations. And the same thing with windows. I think you could make that section make sense if you added, to the extent these are items that are the responsibility of the association.
So guys, we're already seeing a lot of questions in our chat, and they want to know, for condominiums and cooperatives that are lower than 3 stories, do they have to reserve for structural integrity? Don't all
Well,
answer at once.
Rob?
my opinion is yes, because what the statute says is buildings of, there's associations with buildings 3 stories or more have to get this study done. However, when it talks about waiving or reducing or using for reserves for a different purpose, it doesn't reference the study. It references the list of items in new paragraph 2G. And in my opinion, every association has those items and has to reserve for those items. You just don't have to get the formal study as defined by the statute. That's how I interpret it now.
No, I agree with you. Again, poorly written because it's almost inconsistent, but that's the result.
Right. Again,
For all condominiums and cooperatives, another question, do they now have to pay for a professional reserve study, whether it's for the structural integrity or not? You know, and the structural integrity reserve is only every 10 years, correct?
Right.
Right.
Remember, a lot of clients, a lot of communities over the years have relied on roof consultants to come out and tell them what, you know, estimated remaining useful life on the roof, although the roof is now part of that structural integrity reserve. Same thing with exterior painting. Exterior painting and waterproofing is part of the structural integrity study. I mean, I will tell you, my recommendation to clients is going to be, I think the days of pulling, you know, numbers out of thin air on reserve schedules needs to be over. I think that's your safety net, hiring a professional reserve study. To me, if you don't do that, you really are operating without any sort of safety net. If somebody comes back and says, where did you come up with these numbers?
Right.
Absolutely. The study gives you the cover that you need to say that you are fully funded per that reserve study, as opposed to something else, whether it's your hypothetical treasurer made that up, or it's the way we did it in New Jersey, or it's based on our prior experience.
Right.
Get the reserve study to provide you with that cover.
Well, guys, we've got less than 10 minutes if we're going to stick on schedule here. We've talked about the milestone inspections. We've talked about the new structural integrity reserve study. And obviously, there's going to be increases in reserve funding, and there's going to be necessary repair and maintenance work. Now the question is, how are they going to pay for all this?
Well, one thing I want to make clear, because I think I did see a question in the chat, the fully funding obligation begins January 1st, 2025. We agree on that. I mean, that the budget that starts in January 1st, 2025, because you can no longer waive or reduce reserves effective December 31st, 2024 with respect to the structural integrity reserve item. So that's when so I guess your 2025 budget is when you have to have fully funded reserves.
Right.
Under the statute.
Marathon. Don't start training the week before. Okay.
Right. But you need to be starting now for a variety of reasons. You know, to your point, you know, about paying for it, you know, some associations have limitations on how much they can increase the budget. Now, reserves typically don't factor into that, you know, particularly with the 15% increases and that sort of thing. But just as a general matter, you know, stepping up now is going to, you know, put you in the best position to get to fully funded, you know, by 2025. But as far as paying for it, I mean, there's only 3 ways to pay for anything. You save for it, you specially assess for it, or you borrow it. I mean,
That's it.
I mean, I guess there is the lottery, but that's that's a tax on people who can't do math.
And I'm not sure that's a common expense for the board to purchase
Lottery tickets. No,
probably not. So yeah, I mean, I think if you've not been fully funding your reserves, you should have a very strong conversation. I mean, even, you know, should you adopt an amended budget this year to increase reserve contributions to try to start getting right with your reserve obligations going forward?
I have clients doing that.
Yeah,
I have several clients amending.
You know, it's you know, for associations who have taken a laissez-faire approach to their reserves, not to put too fine of a point on it, but the bills come due. And it's going to be very painful for certain people.
Steve, I think one of the legislative proposals, one that was not incorporated into Senate Bill 4D, did address the fact that in some communities, there are handcuffs on the board's ability to specially assess. There are handcuffs on the ability to increase the budget. Sometimes there's monetary caps right there. And if we've got owners who, they don't care. They're not the ones that are actually subject to the breach of fiduciary duty claim. They're not the ones that have a fiduciary duty. That was in one of the proposals. I'm disappointed that it didn't pass. But if you've got a board that's hamstrung with those kind of documentary provisions, what's the alternative? Seek a deck statement or?
Well, first of all, Donna, what I would try to do is at least minimize the hamstringing and go to the membership now for an amendment saying, okay, we have a cap of X, whatever it is, how it's phrased, and say, except as required by law. So if we are required by law, for example, to fund these reserves, and it pushes us over that number, we have to do that. Or to make repairs required by the phase 2 investigation, say, well, we don't have enough money to do that, so we're not going to do it. I don't think any judge will have much sympathy for a board who says, hey, we're protected by the cap and we did nothing about it. So at least try to remove the hamstring, as you called it, the restrictions on assessing or budgeting or funding of reserves so that you can actually comply with the statute.
Rob, I'm sure you've got a lot of retirees in your area too that are saying, we've got people on fixed incomes. They just, they just can't afford these kind of increases. Are you hearing more and more about possible terminations and sales of the building?
I think we will. I don't think that, at least so far in my experience, I haven't had any direct inquiries about that, but we're definitely, I think, anticipating buildings are going to be looking at, is it still a good business decision to operate this facility as a condominium or cooperative, given the costs that are going to be required to bring the building into compliance, whether that is due to the milestone inspection or due to just their routine structural reserve obligations. I think we're going to see that issue come into starker contrast when we start getting those reports and those reserve studies in the next year or so. And I think termination for some buildings may be appropriate. Now, the issue there is, termination as a concept for condominium associations is outlined in the documents and the statute, but that's really only part of the process. You've got to have a developer or somebody wanting to, buy your building, presumably for the land underneath your building. And if you don't have a suitor who's willing to come in and make that a viable transaction, terminating just to terminate doesn't really improve your situation.
Although they're out there. Let me tell you, the developers are out there, particularly for the older buildings that along the coastline. We're not going to create more coastline. It's important, this bill applies to cooperatives, and a lot of those cooperatives still have land leases in place. Yeah. And those lessors a lot of them are not really making all that much money on those leases, and potentially they are exposed to a lot of these issues related to deferred maintenance and other challenges that older buildings in geographically vulnerable locations experience. So I think we're probably going to see more and more cooperatives that may make valuable targets for redevelopment. I will just say this by a little bit of editorializing, is that, back in the 60s, 70s, 80s, it was, marketed as living in a multifamily building in a condo or a co-op on the Florida coastline was the most cost-effective housing option for people coming to Florida, right? It was basically maintenance free. It was cheaper. You could get a condo, right? I think what we're going to see in the coming years is that living on the coastline in a multifamily building is going to be the most expensive housing option. It's going to be for the rich people to live in many of these. And what's going to happen is the older ones will come down, newer expensive ones will come up, will go up, and people on fixed incomes may, start moving more inland, make decisions to have, single family housing. But I think there's going to be a huge shift in what constitutes cost-effective housing in Florida, particularly along the coastline.
Yeah, and I think, on the West Coast where I am, we don't really have, because of the age of our housing stock, the high-rise cooperatives. That's not a phenomenon over here. That's really more an East Coast issue. Our cooperatives are typically bought out 723 mobile home parks. But to your point, I mean, that's exactly what's going to happen is buildings that are no longer, financially feasible to maintain are going to have to be, redeveloped. And I think, to stay on the editorialization, the next 10 years under this bill, I think, are going to be growing pains.
Yeah.
But I think after that, on the other side, the condition of Florida's condominium and cooperative housing stock is going to be much better. You're going to have fully funded reserves. You're going to have buildings that are being, properly inspected and maintained professionally. Buyers are going to see the value in that. Even now I have clients who see in the difference between, similarly situated buildings where one has fully funded reserves and others have been waiving. I mean, that has a direct impact on the prices you can get for units, because buyers recognize they're not buying into a special assessment in the next few years.
Sure.
So, I think this bill needs work because we've identified there's places where it's unclear. But I think at the end of the day, this type of legislation is going to, be a net positive. At least that's how I see it.
I agree with you. Steve, we've had federal legislation, the SAFER Act, that's been touted as being helpful for the people on fixed incomes that I just discussed and Rob just discussed, who may be subject to special assessments. But from my reading of the legislation, I don't know that it has as widespread impact as maybe the drafters would have hoped.
No, I agree with you, Donna. It is limited and it's focused, targeted, whatever, for particular owners in particular properties. For example, you have to be qualified as either VA or HUD compliant to have a mortgage, federal programs, federal financing programs. That by itself excludes a lot of properties, and there's some other limitations in the legislation. But if you fit within the SAFER definitions, by all means, there are federal funds available for you to meet the needs. And they may be the ones who need it the most, but at least there is something there, because that's one more way of financing the improvements and the repairs that are going to be needed after you get these studies done.
Yeah. So we're bumping up against, we're at 3:04. Folks, if you've hung in here this long and we've got almost 2,000 people that are still with us, we can't let you go until we talk about what the potential liability is for board members personally and for the association, because it's written right into the statute, which is new, and that should be a big, bright, blinking light to everyone that they're serious about this, that there is drafted right into this safety bill language that says that board members can be found to have breached their fiduciary duties if they fail to undertake the milestone inspection, and if they fail to undertake the structural integrity reserve. So Rob, why don't you kick us off with the list of horribles that can happen if a board misses these deadlines?
Well, if you're found to have breached your fiduciary duty, you can have personal financial liability. The statute 718-111 1A or whatever the sub is that deals with the fiduciary duty states if you act in a list of ways, including willful or wanton to the that causes injury to persons or property, you can have personal financial liability. So failing to get these inspection reports done is a breach of your fiduciary duty. And if that failure causes an injury, whether to property or persons or otherwise, you can have board members could have personal financial liability. So, this is, I think, cannot be overstated how seriously boards of directors have to take these obligations.
Rob, I read that one a little differently.
Oh, maybe I misspoke.
Well, no, I don't think you misspoke. I'm just reading it differently by way of, I think what the legislature intended here is strict liability to create breach of fiduciary duty. You don't do the report, you don't need the injury, you don't need anything else. It's the non-compliance. So this is them saying, and I mean it.
No, I agree. I think that the failure to do it is a breach of your fiduciary duty. I think the next part of that is, when do you get personal liability?
And what about D&O coverage? We've done webinars with insurance experts, and this has come up, and they're kind of scratching their heads, but there may not be D&O coverage.
Yeah, and
I agree. Yeah.
Yeah, or going forward, they may write out exclusions.
Right.
For
And
that.
we only talked on it ever so briefly, but for all our CAMs listening, they haven't overlooked all of you either in terms of potential liability.
That one's kind of interesting because I think, Donna, there's a little bit of a hedge there. And for the CAMs, it's lines 183, 184 in the bill itself. It's page 7 of 88. And it basically says that it's not really a responsibility unless it's as directed by the board. And so, message for the board members, direct your CAM to comply. And CAMs, you might want to be a little more proactive about it also. But as far as the CAM goes, it's as directed by the board. That is something to consider. Be aware of it. It's very much like what Rob was talking about, the fiduciary duty issue. It's there, and if the board tells the CAM to do it and you don't, then you have responsibility or liability.
But again, you've directed your CAM didn't do it, and your management agreement has you indemnifying the CAM for gross negligence. So this becomes very circular.
Absolutely.
This new law, it really would be a good idea to look at all of your contracts, to look at your management agreement and see what you've agreed and see what the scope of duties is for your licensed manager. And this is good for managers to know as well, because if there are not clear lines of communication for the manager could be at risk in terms of knowing whether or not they've been directed to do something. So it's certainly, as Rob said, we cannot overstate that, the potential for personal liability is there. And as Steve said, the potential for that to be construed as strict liability is there. And I do want to mention one other thing that came up recently, because we are still in the midst of a property insurance crisis, which I'm sure our legislators are going to fix, right? I'm sure they'll fix that. They'll get right on that.
No comment.
But one of the issues with that is that at times you have owners that are, pushing boards to self-insure or to underinsure, and there's language in the statute that makes it clear that if there's not sufficient insurance coverage, every unit owner has personal liability up to the market value of their homes. And I don't know how many owners realize that.
Yeah. Well, going back, and Steve mentioned this earlier, I can't imagine that insurers are not going to require proof that the association has these reports when required to get insurance. It's going to be, varying levels of obligations on associations to have these reports, not just for this express reasons in the statute and providing it to the owners as required, but you're not going to get mortgages. You're not going to get insurance. You're not going to be able to get, loans from the association. The association's not going to be able to get loans to do work if you don't have these reports. It'd be my expectation. It's, you're going to have real problems operating in the business world without these reports, because no insurer, no lender, no mortgagor or mortgagee company is going to, you know, lend money or become involved if you're not up to date on these issues.
All while we're still trying to pitch the state of Florida as a very attractive alternative for people retiring to come down here, as opposed to going to Arizona and other places in the country. No, we've got our work cut out for you to bring this full circle, because we're talking about legislation. I want to get back to where this all started. I mean, in my opinion, safe buildings start with the people who build them. Is that a fairly elemental? People who build them. And, you know, we've been hearing that developers are not entirely thrilled with this with SB 4D, because it doesn't allow them to waive reserves any longer. You know, we also see that there's been a trend over the last 15 years. Every single session, we've had a bill that's been proposed, that's been sponsored by Florida legislators, that would make it more difficult for associations to pursue, and even just single family homeowners, Florida consumers, to pursue contractors and developers for shoddy work product. And what boggles the mind is we saw another one of those bills proposed this very year. In the aftermath of Surfside, we saw yet another bill that would have reduced the statute of repose from 10 years to 7 years, which obviously makes that's the outermost limit to go after a contractor for bad work. So Steve, I'm gonna throw this over to you, because I know you do a lot of work with the legislature. Is there any chance that we're ever going to see a reversal of that trend? Because look, this bill was intended to increase transparency, enhance safety, and to address fiscal operations to ensure building safety. How, on the one hand, can you do that while on the other hand not understand that you could have a building that's doing everything right, putting away reserves, conducting these inspections, undertaking the repair work and the maintenance that's needed, but they're doing business with contractors who deliver a substandard product, which does not make their building any safer?
Yeah, I don't see it. Reality tells me, or at least my view of reality tells me, that it's not going to happen anytime soon. And I think that—
And by that you mean we're not going to see a reversal of the trend?
Correct.
Florida Builders Lobby is pushing.
Correct. But I would urge everybody who is listening or who does listen to this webinar from time to contact your legislators and let him or her know that this is important to us, that the statute of repose, which for the non-lawyers is the outside limit of filing the claim. So you can have negligence claims with statute of limitations, say 4 years from discovery. As Donna was indicating, they were trying to push it down to 7 years. And if you look, you know, Rob gave us all the timelines and all of that. None of these inspections that would produce the meaningful information are going to occur within that time period. So it's not going to help us. But if we're looking for that monetary relief that really isn't in here either, then let's try to hold the people responsible who actually did it and say, yeah, we do need a potential cause of action that maybe coexists with the timeframes that are in this statute. Start there and ask them to reconcile the two concepts, because right now the deck is stacked against the association.
So we're at 3:15. Any final thoughts on the law, folks? We told you we'd have you out of here by midnight. So any final thoughts on the law before we wrap up?
Yeah, I was thinking about this. I've practiced community association law for 15 years. You know, there were some big amendments in 2008 dealing with insurance, but this is probably the most significant legislative enactment for condominium and cooperative associations, you know, I've experienced in my career. You know, we've had it for what, 2 weeks now. I think it's hard to really predict all of the downstream consequences. I mean, is it the biggest amendment to 718 since 92? I wasn't practicing in 92, but Steve might have been. I know Donna wasn't, so.
Yeah,
You know,
Just starting, just starting.
there you go.
I was a sophomore in high school, but so yeah, it's huge. It's going to have real serious downstream ongoing consequences for every condominium association in the state of Florida. Other than that, it's not a big deal.
Yeah, other than that, okay. Steve, last word?
Yeah, it's just money, right? No, seriously, yeah, it is the largest change, and I have been practicing a little bit longer than the 90s changes that we saw, or the 80s changes that we saw. And yeah, it's a life safety issue. It needed to be done. It's not perfect. Some people would say it's not even good, but it needed to be done. It's a good first step. It's got a lot of indications that the legislature recognized the need for changing this. Will it change? Probably. We just can't count on it. But for now, there are, as I think Rob said, some growing pains to go through. The next 10 years are going to be difficult. It's going to be expensive. I mean, let's just call it what it is. But the other side of it is at the end of that period, we will have the safer homes, the more valuable homes, and a condominium act that does protect the consumers better than it has before. So I think it is a great start. It just needs a lot more work.
Yeah.
Well, Steve, Rob, and I want to thank everybody who joined us today. I want to reiterate again that the webinar will be available. I'm not sure today, but give us a day or two at www.flbuildingsafety.com. So for your board members or neighboring associations that weren't able to attend, you can direct them there. And as I said, you may want to check back at that webpage because we will start adding information, including that reporting form, Rob, in terms of what they have to send in. Thanks, everybody.
Thank
Thank
you.
you, everybody.